How can I help?
I'm trying to figure out what this can is.
Sure.
I didn't want to be known as the blind judge. After 30 years on the court, I feel as if I've become a judge who happens to be blind. I feel like, you know, my record as a judge, I don't really have to worry anymore about what people think about whether I'm blind or not. The basic problem here is that we have a court that is all too often not faithful to really fundamental principles of judicial restraint that are really quite essential to preserving the separation of powers and the checks and balances that make our government work. And that process has accelerated in the past decade or two as our country has become more political and as the court has become more political.
Good afternoon and welcome to Washington Post Live. I'm Jonathan Capehart, Associate Editor at the Washington Post. In Vision, a memoir of blindness and justice, federal judge David Tatel writes, quote, "Hindsight is 20/20, but memory isn't. I think the truth is that I was deeply in denial and just trying my best to get through each day as it came." Judge Tatel retired earlier this year after serving 30 years on the powerful and prestigious D.C. Circuit Court of Appeals. In his memoir, he writes about his career on the bench, but more importantly, he goes deeper into the loss of his eyesight in his 30s due to retinitis pigmentosa. Joining me now is retired federal judge David Tatel. Judge Tatel, welcome to Washington Post Live.
Happy to be here, Jonathan. Thank you.
So before we get started, I would like to give a verbal description of myself for our audience. I am a devilishly handsome and newly minted 57-year-old Black man with close cropped hair, a little salt and pepper stubble on my face, and I'm wearing brown chunky frames, a navy blue blazer, and a blue gingham open collared shirt. Judge Tatel, please give a verbal description of yourself before we begin.
Sure. I, too, am a devilishly handsome but slightly older white man in my early 80s. I'm wearing a jacket and a blue tie. And most important, sitting behind me to the left is my beautiful German Shepherd guide dog, Vixen.
And we're going to talk about Vixen in a little bit, Judge, but let's start with the title of your book, Vision. And the hindsight quote I read in the intro. You also write that you regret not talking about your blindness sooner. Why?
I regret it because, let me explain why I didn't talk about it. When I was first losing my sight, I was a teenager, and teenagers want to be like their friends. I didn't want to be different. And as I grew older and started practicing law, I worried that my declining sight would not be helpful to me professionally. But as I look back on it, I don't disagree. I don't second guess what young David Tatel did, but I do think my life would have been easier and less tension-filled had I been more honest about it. I spent a huge amount of energy and effort to downplay my declining sight and to cover it up. And looking back on it, I think it would have been easier for everybody around me and myself. For example, I could have used a cane years before I finally got the courage to use one. And most important, you know, I should have gotten a guide dog years before I got Vixen.
Okay, this is the second time you've mentioned Vixen in with it less than 5 minutes. So I'm just going to jump ahead and let's talk about Vixen, because we have a headshot or two of Vixen that we are showing your audience. you write in your book that Vixen is, quote, the dog who changed my life. Talk talk about that and how the addition of Vixen to your life emboldened you to talk about being blind.
Yes, I got Vixen in my late 70s, not until then. And Vixen has done two things to me, really. One is she's given me and my wife Edie an enormous amount of independence. Before Vixen, although I had a cane and was pretty good with it, I still had to spend a huge amount of time planning. The logistics of moving around were complicated, getting across particularly busy streets, things like that. Now with Vixen, I'm on my own. I can go back and forth to the office by myself on the metro. We live in the country, and Vixen and I go for very long walks. I never was able to do that.
Mm.
And at the same time, she's given Edie the independence to be able to not go walking with me if she would like to. The other thing, Jonathan, is that yeah, I got Vixen pretty much at about the same time I started this memoir. And the two of them together, thinking deeply about my life and my adapting to declining vision, and then ultimately to life without sight. And Vixen gave me the freedom to talk about it in ways I never could. If you're walking around with a cane, people don't want to talk to you about you being blind. They're respectful. They're just, blindness is not a topic. When you have a guide dog, you cannot escape being a blind person because everybody wants to talk about Vixen. How does she work? How does she get you across busy streets? Where do I get a dog like that? So Vixen opens up conversations and has made it comfortable for me to talk about things that I was never comfortable talking about before, ever.
And it's one thing to not be comfortable talking about these things. It's another to put those thoughts and those feelings and those emotions down on paper. How difficult was it for you to do what is necessary to write in writing a memoir? And that is not just writing about what happened, but how
Yeah.
what happened made you feel.
If 5 years ago, if you had shown me this book and told me I would write it, I would say, no way. I was not either comfortable or willing to talk about blindness the way I do in the book. But the process of writing it and of mainly discussing it with Edie, the two of us Edie worked on this book with me. And it required that we think deeply about our lives together and how blindness affected her and me and our marriage and our children. And we found ourselves talking about issues that we had lived through but didn't talk about.
Hmm.
And it was a revelation to both of us. This book, I say in the prologue to the book that the book is a coda to my adventures, both of living without sight and of being a judge. And that really is what it is. The book was part of the process of learning to deal with and accept my blindness. And yes,
So we've talked about Vixen. I was going to
yeah,
talk about Vixen and Edie, and so now you've mentioned Edie multiple times. Let's talk about
right.
your wife Edie. You said she worked with you on this book. Talk more about how the resources that you had, including Vixen, how that's helped her navigate your blindness.
Well, yes. The book, although it's my memoir, this is a memoir also of our lives together. This August, we will have been married for 59 years. And Edie lived the loss of sight and blindness just as much as I did. It was not just me, it was both of us together.
Mm.
And fortunately for me, she's also a brilliant writer. So when it got around to working on the memoir, we wrote it together, which gave us the opportunity to discuss these issues we hadn't discussed before. And she learned more. She learned all kinds of things about me while we talked and wrote. There were moments when I would draft something and send it over to her computer, and I'd hear, she would be reading, and I would hear, "You did what?" So we we had many moments like that. Some of them tension filled, but we're still happily married and looking forward to our anniversary this summer.
Wow, 59 years is
Yeah,
quite an achievement. Congratulations in advance.
thank you.
Did Edie push you to go further, to open up even more with what you were sending her?
I wouldn't say push, Jonathan. I'd say she asked questions, hard questions about things I wrote. And she said, I have a hard question for you. Why did you do this particular thing? What was going through your mind? And it made me think about it. And she didn't push me because I think she knew that if she did, I would have pushed back. But she asked really good questions, and that helped open up many issues for us to talk about.
I'm going to go back to what was going to be my second question in this interview, and that had to do with President Clinton. You commented that President Clinton never mentioned blindness in your nomination to the D.C. Circuit Court of Appeals. The
Right.
question was going to be, when did you begin to get comfortable with people knowing you were blind? But was that a conscious decision on your part or the administration's part to not mention your blindness?
Well, I can tell you this, that 25 years earlier, when I became director of the Office for Civil Rights at the old HEW, Department of Health, Education, and Welfare, during the Carter administration, they actually asked me whether they could put in the press release about my appointment that I had a visual disability. And I said no. By the time President Clinton appointed me, by then I was using a cane. People knew that I was blind, but they also respected my desire not to talk about it.
Mhm.
And I don't ever remember actually having a conversation with the people in the White House about that, but they didn't mention it either. But literally the press reported it as the first blind appellate judge. I knew that would happen, and I wasn't at that point comfortable with it, to be candid. I really, really wanted to be a federal judge. I wasn't particularly interested in being a blind federal judge, but that was the circumstance. And looking back on that also, I regret that. I wish I had been more forthcoming. I think having a blind judge on the United States Court of Appeals for the D.C. Circuit could be inspirational, not just for blind people, but for people who aren't blind and who are worried about the capability of blind people. One of the reasons why I'm convinced, Jonathan, I didn't talk much about my blindness and tried to cover it up was, although I had lots of role models, I didn't have any blind role models. And, what I've discovered while writing this book is maybe this book can provide that for people going through the same thing I did. Maybe they can see this book in the presence of a blind judge on the Court of Appeals and say, well, I can do that too. And just as important, I hope sighted people will read this thing, people who hire lawyers, and they'll say after reading this book, if they're say picking between 3 people for a job and one of them happens to be blind, that they make the decision on the merits. That's what I hope this book does.
Just by writing this book, Judge Tatel, you've become an instant role model. So you don't have to worry. You don't have to worry about that. And on
Thank
that
you.
regard, I am really happy you wrote this book. So
Thank
now
you.
let's get into your
Sure.
tenure on the bench, which you write about also in your book entitled Vision, and you detailed the reason for retiring, and you write, quote, "I was also tired of having my work reviewed by a Supreme Court that seemed to hold in such low regard the principles to which I've dedicated my life." Unpack that for us.
My book is about judging and about the principles of judicial restraint, like faithfulness to the Constitution and to the laws Congress passed, faithfulness to the court's own precedent and to its limited jurisdiction. These are the principles that confine courts to the process of judging and keep them out of politics and policy. I've lived those principles during my 30 years on the court. They are baked into my DNA. And for the first 20 years on my court, it was fine. Sure, the Supreme Court reversed me from time to time, but I could look at the opinion and see the court utilizing the same judicial process that I did. Yes, they maybe reached a different decision. They maybe interpreted a statute differently than I did, but they didn't ignore the statute. They maybe interpreted a precedent differently than I do, but they didn't disregard it. So even though I would be reversed once in a while, I did be affirmed quite often too, by the way, that was fine with me. The Supreme Court's the highest court in the land, and its job is to review the work of lower federal courts. And as long as it was doing it on principled terms, I was fine with that. But recently, in recent years, this court has all too often abandoned those important principles. And I am bound by the decisions of the Supreme Court as a lower federal court judge, and I became increasingly uncomfortable with the notion that I would have to apply them, particularly since they had such adverse consequences for our country.
And on that regard, there are two Supreme Court decisions from this last term, among many, but just want to focus on two that will have enormous implications. One is the Chevron doctrine,
Right.
which
Yes.
you write about ruling in many climate-related decisions. And in that you write about the Chevron doctrine at great length. The Supreme Court did away with that precedent. What do you make of that, of the lack of judicial restraint shown in that decision? Has the court gone rogue?
There's probably no case I applied more often in my 30 years on the court than Chevron. And to me, Chevron was a workable way of enabling the many federal agencies we have to do their work, often complex work involving the environment and the nation's financial system and many other things, allow them to do their work without judicial interference, but also preserve the ability of the courts to strike down agency decisions when they exceeded their statutory jurisdiction. To me, it worked, and it worked for all those years for the Supreme Court. Also, it too applied Chevron. But this court has suddenly found that that the Chevron decision rests on a flawed legal principle. I don't agree with that, but I do think that if there were problems with the administrative system, if agencies were exceeding their authority too often, then that's a job for Congress. Congress created them. Congress gave them their authority. Congress can hold hearings. And Congress, if it wanted to, could have overruled Chevron because it believed that it was resulting in rogue administrative law decisions. But it didn't. It didn't. Instead, the Supreme Court, the unelected Supreme Court, which had been applying Chevron for decades itself, suddenly decided that this opinion is now unlawful and will no longer be followed by the courts. And so, in terms of the theme of my book, Jonathan, this is an example of the court not respecting its own precedent. This is the kind of judicial decision that has made me so uncomfortable remaining as a federal judge.
Before I get into the second case, the immunity case, what you just said at the end there, I want to bring in an audience question. This is a question from Lawrence in Maryland. And Lawrence asks, how has the current U.S. Court of Appeals changed since you first joined? Is it more politically divisive now than before?
I don't think politically divisive is the right word. It's definitely a different court than the one I joined. The court I joined actually, there were more Republican appointed judges on it than Democrat. Now it's the other way around. The DC Circuit has over the years been quite a collegial court. It's worked well together. I would say that as the issues before the court have become more complicated and more controversial, I would say so have the decisions themselves. Yes, the court has changed, not as much as the Supreme Court, I would say.
So let's talk about that second decision, the immunity decision. At the end of one chapter, where you write about the Supreme Court's basic invalidation of the Voting Rights Act, you write at the end of that chapter, quote, "I fear for our democracy." And those are the same words that were used by Justice Sonia Sotomayor in her dissent of the immunity decision. You told my MSNBC colleague, Stephanie Rule, that you, quote, "fear for it even more as a result of that immunity ruling." Talk about why.
So what my fear for democracy was all about in the book, it was about the voting rights cases. And yes, the suppression of the vote is definitely a threat to democratic values. But a greater threat was the way in which the Supreme Court in Shelby County reached that decision. It invalidated the Voting Rights Act, the most important provision of the Voting Rights Act. And it disregarded the plain text of the Constitution in doing so. It disregarded its own precedent, and it disregarded Congress's will. It was a deeply unprincipled decision. They could have accomplished the same result through principled ways. It wouldn't have bothered me as much, but it was a deeply unprincipled decision. The immunity decision that came down 2 weeks ago is the same kind of case. The Supreme Court holds that former presidents enjoy immunity from criminal conduct committed while they were president. Well, where does that come from? It's certainly not in any law Congress passed. I mean, the nation's criminal laws don't exempt the president. It's not in the Constitution. In fact, if anything, the Constitution suggests there is no presidential immunity. The framers of the Constitution knew how to grant immunity when they wanted to. They gave it to senators and congressmen in the speech or debate clause, but they didn't give the same immunity to the president. And in the impeachment clause, they even expressly said that an impeached president can be criminally prosecuted. So I look at the Constitution and the laws of Congress. I see no immunity. To me, that's the end of the case. Now, the court talks a great deal, in its opinion, about its concerns about what will happen if presidents, while they're in office, face the prospect of future criminal prosecution. Will it restrain their ability to perform their function as president? Now, maybe they're right about that. Maybe they're not. But that is a question for Congress. If Congress thinks, because the Constitution doesn't grant immunity, that's the end of the court's role. If Congress wants to have hearings and consider the risks of prosecuting former presidents, that's where democracy resolves questions like that, not by the unelected judiciary finding a principle that doesn't exist anywhere in the Constitution.
Let's keep talking about the Supreme Court and trust. You recently spoke about the Tatel 5-minute rule. What is that rule, and why do you think it would help to uphold public trust in the court?
So the reason the public respects courts is because the public perceives that courts are functioning as courts and not as policy or political institutions. They're not Congress, they're judges, and they're applying the law to the facts objectively without regard to their own views or their own interests. That's why the public supports courts. So in my years on the DC Circuit, judges always face the question of, is there something you've said in the past, or something you've done, or an investment you have, or some personal view that should require you to recuse yourself from a case? That is not here the case. And the reason that's important is that the public, to have respect for the courts and to obey the rules of courts, the decisions, has to believe those are objective acts of judging and not the result of outside influences. So I think the Tatel 5-minute rule would work this way. If I was facing a question of possible recusal, which didn't come up that often, but it did more in my early years on the court, but later, and I talk about this in the book, in terms of my blindness and its possible implications for decision-making. My view was that if I had to think about the issue for more than 5 minutes, I recuse myself. And that's because if I had to think about it for 5 minutes, I thought it was hard enough so that I should err on the side of recusal. And that's the rule I followed for 30 years. Now, Jonathan, it's much easier for me, an appeals court judge, to recuse himself or herself than it is for a Supreme Court justice, because when I recuse myself in the case I talk about in the book involving currency, the accessibility of U.S. currency, another judge took my place, and a 3-judge panel resolved the case. The Supreme Court justice, when a Supreme Court justice recuses himself or herself, it puts a much greater burden on the Supreme Court because there's nobody to replace that judge. It means you have an 8-justice court instead of a 9-justice court, and that's why justices really have to be very careful not to recuse themselves. But I think that imposes on Supreme Court justice an equally strong obligation to be sure they don't involve themselves in situations that might require recusal.
Mm-hmm. I'm going to smash two big questions into one, still sticking on the court. One, do you think Justices Alito and Thomas should have recused themselves from the recent Trump immunity decision, given the situations involving their spouses, that calls into question their impartiality? And then in answering that, Judge Tatel, your reaction to news coming from Congresswoman Alexandria Ocasio-Cortez of New York that she's going to file articles of impeachment against Supreme Court justices.
Jonathan, I wrote my book about the Supreme Court of the United States as an institution. It's not about the justices. I rarely mention the justices except to identify who wrote an opinion, and I'm not going to change that now. I'm committed to that proposition. I've been willing to talk about my own recusals, as I do in the book, as honestly as I can. In terms of impeaching justices, I think that's a bad idea. I think the impeachment clause is reserved for high crimes and misdemeanors. I think if we start threatening to impeach judges because of their opinions, it's going to politicize the court even more. I think it's not a useful idea.
Okay, so let me just, let's say a justice has been found to not have been 100% forthcoming on their financial disclosure forms over the period of years. Would that not warrant, and to the tune of millions of dollars, would that not warrant articles of impeachment against the person to hold that person accountable in a lifetime seat?
I think if a justice robbed a bank, yes. But beyond that, I don't think failing to file a fully developed financial disclosure form rises to a high crime and misdemeanor.
I had to try. Judge Tatel, we're running out of time, but I want to squeeze in this one last question from an audience member. This is from Annette in Pennsylvania, and she asks, what is the civil right you wished more young people understood and acted to protect? Are you hopeful or not hopeful about this right in the future?
I would answer that question the same today as I did 50 years ago when I was running the civil rights program at HEW. I think the most important civil right is the right to be free from discrimination based on race, gender, and disability. And I think the most important attribute of that is the right to vote. And I think defending the right to vote to ensure that everybody who is eligible to vote votes, and that no one is denied the right to vote based on race or any other illegal qualification is probably the most important civil right we have right now.
Retired federal judge David Tatel, author of Vision, a memoir of blindness and justice. Thank you so much for coming to Washington Post Live.
My pleasure, Jonathan. Thank you.
And give a pat on the head to Vixen for us. And thank you for joining us. For more of these important conversations, sign up for a Washington Post subscription. Get a free trial by going to that address there on the screen, washingtonpost.com/live, washingtonpost.com/live. Once again, I'm Jonathan Capehart, associate editor at the Washington Post. Thanks for watching Washington Post Live.